I beg to move for second reading a bill shortly entitled Payment System and Services. Mr. Speaker, this bill is a creature of the Eastern Caribbean Central Bank, and it aims at harmonizing the processes and the procedures of payment systems and services providers in the region. Mr. Speaker, the purpose of the Payment System and Services Bill is to provide for the licensing and regulation of payment service providers and the oversight of the payment system. Mr. Speaker, payment service providers means people like Shopee and Penny Pinch and these kinds of organizations. Presently, the advancement of the operation and regulation of the payment system generally and particularly is provided for under the Payment System Act, Cap 12.24, the Act. Additionally, the Act codifies the procedures governing the payment system. The Eastern Caribbean Central Bank, for the Eastern Caribbean Central Bank Agreement, has the power to regulate and have general oversight of payment and settlement systems, purchase payment facilities, and netting contracts or arrangements. Under the Act, the Central Bank has exclusive authority for the supervision of the payment system as indicated. Mr. Speaker, the payment services landscape has changed dramatically, and the Central Bank, interested in nurturing a payment system environment that attracts innovative payment services from non-bank service providers in the interest of financial inclusion and the reduction in the use of cash, drafted this bill with the assistance of regional legislative drafting consultants. In addition, the bill is an integral component of the Central Bank's modernization and development plan for the payment system in the Eastern Caribbean Currency Union, ECCU. It is also part of the Caribbean Digital Transformation Project in the Eastern Caribbean, spearheaded by the World Bank in collaboration with the organization Eastern Caribbean States Commission. Between 2021 and 2024, the bill, through several consultations, was reviewed by Attorney Generals and Parliamentary Council in the Eastern Caribbean Currency Union. In June 2024, the bill was recalled by the Central Bank to make provisions for the inclusion of the Office of Financial Conduct and Inclusion, OFCI. However, the Central Bank made the decision that the bill is enacted with the understanding that the amendments to make provisions for the OFCI will be undertaken following its enactment. The bill had its first reading in the House of Assembly on 10 December 2024 and in the Senate on 12 December 2024. As a result of the bill not being presented for second reading during that session of Parliament, the bill had to be reconsidered by Cabinet for transmission to Parliament for enactment in the new Parliament system. The objectives of the bill, Mr. Speaker, are to introduce a comprehensive licensing regime calibrated to specific tasks, to specific risks posed by the activities through a new modular approach to regulation that facilitates growth in innovation and financial inclusion. Broaden the scope of regulated activities to non-banks to accommodate a wider range of payment services and activities. Strengthen consumer protection. Engender confidence in the use of electronic payments and enhance safety and efficiency in the Eastern Caribbean Currency Union payment system and the capacity to maintain financial stability. The bill makes provision for its purpose under Clause 3 of the bill, which is to establish a legal framework to enable a payment system that is safe, efficient, resilient, inclusive, and competitive for the management of risk, the maintenance of financial stability, and the protection of the interests of consumers. Part 1 of the bill contains the administrative provisions. Therefore, the functions and powers of the Central Bank are set out in clause 4 to 8 of the bill. Generally, the central bank is empowered to monitor and oversee the payment system, promote financial inclusion and financial innovation, protect consumers and ancillary to these powers, continually modernize the payment system through new policies, establishing standards and procedures, and monitor and oversee the clearing and settlement system. Additionally, the bill empowers the central bank to support the operations and participants of a payment system, including ownership and participation. The central bank is also empowered under the bill to establish, own, operate, or participate in the ownership of a system, act as a central counterparty, open and hold accounts for an operator or participant, and hold securities for clearing and settlement of transfers, and direct the payment system provider to enter into an arrangement with the operator of the payment system to achieve interoperability of the payment account with the payment system. In carrying out these functions and powers, the central bank, in accordance with the bill, will cooperate with other public authorities engaged in regulation and supervision of financial institutions and other entities directly or indirectly involved in payment services and their operations. In the bill, the Eastern Caribbean Payments Council is established under Clause 9 of the bill for the purpose of advising the central bank on the oversight of the payment system. In addition, the bill makes provision for the composition, appointment of a chairperson, and gives the central bank the authority to make rules relevant to the operations and functions of the Eastern Caribbean Payment Council under clauses 10, 11, and 12 of the bill. Mr. Speaker, under Part 1 of the bill, a license may be issued to a person who operates a system or provides a payment service without a license to do so from the central bank under Clause 13 of the bill. A penalty is created under the bill if a person does not obtain a license in accordance with the bill. Classes of licensing may be created by the central bank after consultation with the Minister of Finance under Clause 14 of the bill. The procedure for obtaining a license is provided for in Clauses 15 and 16 of the bill. Once issued, a license is not transferable according to Clause 18 of the bill, and conditions may be imposed on the licensee, including the conditions in relating to the electronic money order clauses number 19 and 20 of the bill. With respect to the license, the bill provides for the duration of the license under Clause 21 of the bill, renewal of the license and suspension or revocation of the license under Clause 23 of the bill. The Minister, on the recommendation of the central bank, is empowered to prescribe fees which include a non-refundable application fee, license fee, and an annual fee under Clause 24 of the bill. Obligations of the licensee. Licensed financial institutions or credit unions are set out in Clauses 25 and 26 of the bill. Therefore, the license must be displayed of the bill, and in the case of a licensed financial institution or credit union, notice must be given to the central bank in relation to criminal proceedings, insolvency, disciplinary action, and material changes to products and services. The bill also makes provision for operational requirements for the central bank, licensed financial institutions, and credit unions under Clause 27 of the bill. Provision is made in Part 3 of the bill for the oversight under Clauses 28 to 47 of the bill. According to the bill, the central bank may issue rules or directives to any payment system provider or operator, and at any time adopt general standards and criteria for the conduct of payment services or the operational systems. The bill empowers the central bank to monitor emerging and innovative payment systems and technologies, receive applications for the innovative payment system and technology to be reviewed, tested, and monitored, issue guidelines prescribing the mechanisms to review, test, and monitor an application for the provision of an innovative payment system or technology. A licensee and a participant are required under the bill to provide any information requested by the central bank in relation to its business or the business of its affiliates, make staff available for interviews with the central bank or any person appointed by the central bank when necessary. An offense is created for failure to comply or if falls or misleading information may be provided. The central bank, in accordance with the bill, may enter and search premises in the company of a police officer, conduct an audit, or commission an independent auditor to conduct an audit of an operator, participant, or payment service provider, and publish information under certain conditions. The bill imposes a duty of confidentiality on the central bank regarding any information or document obtained during the exercise of its functions under the bill, and sets out exceptions. Restrictions are placed on payment service providers in relation to the use of agents and licensees with respect to the outsourcing of activities and compliance with anti-money laundering and combating the financing of terrorism and proliferation of financing. Mr. Speaker, the central bank may designate a payment system under Part 4 of the bill, in accordance with clauses 38 to 34 to 40 of the bill, and must have regard to matters such as the number and value of the transactions that the system presently processes or is likely to process in the future, the safety, integrity, fairness, transparency, effectiveness, and efficiency of the payment system, and the number and type of participants. The bill also allows the central bank to revoke a designation. The bill makes provision for rules to regulate systems in Part 5 of the bill, under clauses 41 to 43 of the bill, by requiring an operator to establish clear written rules for the governance, management, operations of the system which the operator is licensed to operate, giving the central bank the ability to validate or invalidate the rules of the operator, and providing the central bank with the power to mandate that rules on access to payment, clearing, and settlement systems must not inhibit access to more than is necessary to safeguard against specific risks and to provide the financial operational stability of the system. In relation to consumer protection, the bill provides in Part 6, under clauses 44 to 47, that the central bank may establish rules to ensure transparency of conditions, including fees and information requirements for payment services, and the central bank is required to publish the rules on its website. The bill requires a licensee, a participant, or an agent provide a notice to the customer of a fee for executing a payment service, and to disclose specific terms and conditions to a customer of a payment service involving the customer's account at the time the customer contracts for the payment service. The bill also provides for complaints of a customer to be made in the first instance to the licensee, participant, or agent, and in the second instance to the central bank. Mr. Speaker, the bill also makes provision for settlement, netting, and finality in Part 7 of the bill, as well as winding up an administration of a systems operator, a participant, or payment system provider in Part 8 of the bill. Administrative matters and penalties to be used by the central bank are set out under Part 9 of the bill. Other provisions in Part 10 of the bill include the enforceability of electronic fund transfers, indemnity of central bank officials and other officials, making of rules, directives, and guidelines by the central bank, and making of regulations by the minister. Mr. Speaker, I've tried to summarize the payment system and services bill, Mr. Speaker, as you would have heard and you would have read, Mr. Speaker. That is basically a mechanism by which consumers are protected, and there's a clear process and procedure under which payment systems by third parties are processed for the consumer, Mr. Speaker, all leading hopefully for the consumer to benefit, for the system to be transparent, and for the consumer to be assured that when they go to these, when they access these services, their money goes to the right place and all the processes are correct, so that they can use these systems with confidence, because of the fact that there are certain regulations and laws that guide their processes. I thank you, Mr. Speaker.